Hello everyone, and thank you very much for joining us today. I've just got a few housekeeping points before we start, and also whilst a few more listeners are joining the call. So during the presentation, everybody will be in listen-only mode, apart from presenters, of course. If you have any technical difficulties, you can send a message on the Q&A panel at the bottom right of your screen, and if you just select host and press send, the IT team will be able to deal with your query. And as usual, this event is being recorded, and that means we'll be able to send a copy of the recording after the session, as well as a copy of the slides. We are very happy for you to ask questions as we go along in the Q&A panel at the bottom of your the lower right hand portion of your screen. And you can type questions into that text field, select the drop down as all panelists and press send, and we will try and answer those at the end of the session, or if we can't, we'll answer them during the session, but if we don't get to them in the session, we'll answer them at the end, because we've got about 10 minutes to cover Q&A at that point. So I'm delighted to be joined by my colleagues May and Carine, and it's great that you're joining us for this webinar today, particularly given the good weather. We were just saying that it's true dedication if you're dialing in when you could be sitting in the garden, or perhaps in fact I hope you are sitting in the garden listening to this. So we wanted to run this session today because since the Labour government came in to power last summer, we've seen that there's been a real mission both to get tough on illegal working and start to reduce net migration. So you can see this was an announcement that was made back in November by the Home Office, and on the first portion of that announcement you can see the government is referring to, clamping down on illegal working, exploitative treatment of illegal workers, the various sanctions it's going to take. And to be clear, the Home Office's real focus is in relation, when it comes to illegal working, really is for those organisations that are deliberately setting out to use illegal workers as the basis for their business. They've got no qualms about exploiting migrant workers and so on. So it's clear that this type of action is not really focused at our audience today. But the other strand of that, of the Home Office's mission, is to reduce net migration. And you can see there it's talking about those measures relating to illegal working are also tied in with what it sees as the UK's reliance on, or its over-reliance on long-term international workers. And so the other strand to this new drive on the part of the Labour government is going to definitely be about being tougher when it comes to compliance for sponsorship, but at the same time, frankly, making it slightly more difficult and slightly more, or materially more, as we've seen, materially more expensive, because all of that will most definitely have an effect on reducing net migration. Net migration has already begun to fall since the changes that came in relation to salary thresholds last year, but the government politically has to be seen to make a real difference on net migration. And what we'll talk about today is partly measures they're taking in relation to compliance, but also making the rules relating to sponsorship tougher. And in fact, sometimes it's not just about changing the rules, it's about even a tougher approach that the Home Office is adopting outside its existing rules, and kind of changing the guidance to, or applying it in a slightly different way to get stricter with employers with sponsor licenses. So all of this is with this overall picture to try and make it more difficult and reduce net migration. And we'll talk a lot about measures that seem to really not be focused at the type of your type of organisation, which will be well-intentioned, organised, scrupulous, having decent and robust processes in place. But you can see there that last sentence, the government won't wait until an employer has committed serious breaches before taking action, where there are already signs of rule breaking. So that's a real hint, in my view, that it's going to be looking just as closely at the well-intentioned employer, because it's not just about blatantly, breaching the rules by rogue employers. They are also looking at everybody who might break the rules, or might sort of make a series of small administrative issues. So this is definitely going to catch everybody. And what we hope to really get out of today is to give you an awareness of what the issues are, examples of things that we've seen as a problem, and then some practical advice about how to implement sort of safety measures. So that's what we're covering today. Here's the agenda. So we're going to be talking about right to work checks and some of the changes and pitfalls that we've seen, focusing in on the stricter approach on sponsorship and visa applications, and some of the difficulties that you might experience as an organisation. Talk about some other recent changes and what's on the horizon, and then also finally end up with talking about some of the anticipated changes under the immigration white paper, which we are told is due imminently. So I'm going to hand over to Carine, who's going to highlight what's been happening in the world of right to work check.
Thanks, Annabel. So this slide captures key updates from the February 2025 right to work guidance, and more importantly, the direction of travel from the Home Office. And this is just one part of the wider crackdown Annabel's already mentioned. The Home Office believes a significant amount of illegal working is happening not through formal employment, but via workers, so people operating outside traditional employee contracts. And the issue is that illegal working legislation currently only applies to employees. Technically, at the moment, if you have hired a genuine worker or a self-employed person without the right to work, you can't be held liable for a civil penalty. So the Home Office wants to extend this to everyone engaging in work, or at least a broader group than just employees. And in principle, that sounds reasonable. But in practice, it's messy because, the boundaries between worker and self-employed categories are blurry at best. The updated guidance now makes it explicit that if you sponsor someone who is not an employee, for example, a worker, you are responsible for checking and retaining evidence of their right to work. That's always been good practice and a sponsorship requirement to do checks on the individuals that you sponsor. But now it's formally stated that this applies to sponsored workers, not just sponsored employees. But that is just a very small group of workers. What's also changed is the tone. So the Home Office is now strongly encouraging employers to check the right to work of anyone working for them, even if they're not a direct employee. So that means agency workers, freelancers, consultants, and contractors. Now, to be clear, it's not law yet, but the shift in wording from "you may wish to consider" to "you are strongly encouraged" isn't subtle. It signals a clear move towards imposing broader obligations. And we've also had the announcement that these checks will soon extend to the gig economy. That's a big step, as it would cover casual workers, zero-hour staff, and others sitting in that grey space between employment and self-employment. Now, on paper, that makes sense. As I said, the Home Office believes that is where a lot of illegal working is happening. But in practice, it raises quite serious questions. So, who exactly counts as a worker? Will the changes only apply to the gig economy and zero-hours workers, or to all other workers, including agency workers and freelancers in any type of business? It just raises lots of questions. In any event, there is no legal definition of gig economy, nor is there a clear legal distinction between workers and the self-employed. And that means that a business hiring what it thinks is a genuinely self-employed contractor, and therefore not subject to checks under the new proposals, they face a tough choice. Either stick to the line that these individuals are fully self-employed and risk a Home Office finding that they are workers, or start doing the checks as a precaution and risk triggering a whole other suite of employment rights and tax liabilities. It really is a catch-22, and perhaps that's the point, who knows, with the Home Office. It gets even murkier when you throw tax into the mix. So, for example, if someone is caught by IR35 and therefore treated for tax purposes like an employee, will that mean that these new right to work duties apply to? Who knows? Or does it depend on how many clients they have or how often they work for you? Again, more questions. And finally, will labour providers such as agencies continue to bear full responsibility for the checks on the staff that they supply as their employees, or will the end users be jointly liable too? And if so, could both parties end up facing civil penalties for illegal working? Just questions after questions. So yes, these are just guidance updates for now, and before the change in law to including gig economy workers, or all workers, which is more likely, the government will have to give further thought as to how that will actually work in practice. But taken together, they show a clear policy shift towards tougher, broader enforcement. So if you haven't already mapped your workforce and your supply chain risk exposure, now is the time. Start with a mini audit, look at who works on your behalf and what right to work assurances do you really have on those. So the Varian reports, this was commissioned by the Home Office in late 2024 and really confirms that there's still a major compliance gap. While 89% of employers say that they know right to work checks are their legal responsibility, a significant number of employers believe it's up to someone else, whether that be HMRC, recruiters, or even workers themselves. And that's a huge risk. So there are also sector-specific concerns that jump out quite a bit in this report. 41% of the surveyed employers in the construction and 39% in hospitality sectors say that they believe that illegal working is common. And obviously, given that this report was commissioned for the Home Office, that's a huge red, flashing light for enforcement teams. And then there's the document requirements. Around 50% of the employers surveyed admitted that they'd accepted documents like driving licenses, payslips, bank statements, none of which proved the right to work. So yes, these may be small businesses or resource-stretched employers, but the concern for more sophisticated businesses is that the Home Office enforcement doesn't discriminate and it will affect everyone. So if a wave of penalties or naming and shaming is coming, no one is completely safe. Some of the stats from the report will be surprising, especially to well-organised and diligent employers such as those of you joining us today. But it does indicate, firstly, a general lack of engagement, which may push the Home Office to get tougher on everyone. And secondly, if a sizable portion of employers can't get the basics right, which is what this report really shows, they're really going to struggle when it comes to more complex aspects of right to work checks, which then leads me on to my next slide. So here we've got some common pitfalls that we're seeing, many of which are cropping up even with sophisticated employers. So you've got expired visas not being flagged in time. This is usually caused by human error, spreadsheet mistakes, missing diary prompts, so in some cases relying on the employee to notify you. And if the visa lapses and you don't catch it, you're looking at a civil penalty for having continued to employ that person without the right to work. You've got over-reliance on third-party providers. So if you use a recruiter, temp agency, or an onboarding tool, be clear on who is responsible for what. Unless you're using an IDVT provider for checks on valid British and Irish passports, the liability still sits with you. It's also worth adding that we have come across IDVT providers doing right to work checks for those that require a share code. And that doesn't provide the business with a statutory excuse. So the check still needs to be carried out internally in order for the business to benefit from that statutory protection. And we are seeing that some businesses aren't aware of that. Breaching visa conditions. So that's often seen with students. A lot of employers forget that students have work restrictions and most commonly can only work 10 or 20 hours during term time. And we've seen penalties issued where students quietly exceed the limit because they're on a rota system or they're paid monthly rather than weekly, and no one is actively monitoring their hours. So it does happen quite often. You've also got sponsors who are unaware of secondary employment obligations. So let's say you've got an employee who's a skilled worker, but they have a second job, which they're allowed to do. That second employer also needs to check their right to work and has to understand what visa restrictions are associated with that right to work. And this often gets missed, especially if they're seen as, a part-time or a freelancer. Then you've got employer checking service delays. So if an employee's visa has expired, but they've applied for a new one before the expiry, you've got a 28-day grace period to request a positive verification notice from the Home Office to allow you to continue employing that person with a statutory excuse until the application is decided. Now, if you've applied for the employer's checking service check in time and it comes back negative, in effect that they don't have the right to work, you won't be liable for a civil penalty because you will have done what you needed to do beforehand to establish that statutory excuse. If you apply outside of the 28 days and it's a negative response, or you don't request the check at all, and you simply rely on verbal assurance, then yes, you will be liable for a civil penalty. And it does happen. Employers rely on the fact that they have trust in their employees, but it's not going to protect you from a civil penalty if it crops up. So there's also an understandable lack of understanding of the finer detail for right to work checks. So there's a whole range of different types of right to work checks required depending on the individual status. So you've got manual checks, IDVT, as mentioned before, online checks, the list goes on. And if you don't have a full understanding of the full range of obligations, it's only a matter of time before getting stuck. Examples of this include, extra works for those hiring student visa holders, or you've got the fact that you need a proof of national insurance number if someone provides you with a British birth certificate. Or knowing that an employer's checking service check is required for an asylum seeker every 6 months, even if they can provide you with an application registration card confirming their right to work. And then, it's knowing that that application registration card isn't a BRP and doesn't actually enable them to obtain a share code. So these are just a few examples where we've seen that lead to instances of employees working without permission and civil penalties being issued. I mean, even well-intentioned, sophisticated employers struggle with the increasingly complex, and the layers of additional obligations. And even with the best systems, human error, blurred responsibilities, it causes problems. That tends to cause the most problems, to be honest. And with the direction that things are heading towards broader duties and wider definitions of worker, getting the basics right really is more critical than ever. And on that note, I will hand back over to Annabel.
Thanks, Carine. So slight change in tack now. So these are talking about issues that specifically relate to sponsorship, and in particular, those employers who will in some way seek to recoup visa costs from employees. So we've seen that, in fact, probably most sponsors try and recoup visa costs in one way or another. So that may be a situation where they pay all the visa costs at the outset, or some of the visa costs at the outset from the individual, and then during that individual's employment, they will either seek repayment in any circumstances, so maybe through deduction of salaries or some sort of repayment arrangement. Alternatively, and this is probably more common, we see sponsors who are happy to pay some or all of the costs up front, but then they have what we would typically call a clawback arrangement, whereby if the employee leaves before the end of the visa, say within a 2-year period, there is an arrangement, an agreement whereby that employee would have to pay back some or all of the costs. So that's quite a common situation. It's always been the case that sponsors will probably be aware that you can't ever seek to recoup the immigration skills charge. So that's the amount which is around, for a medium-large employer anyway, that's about £1,000 per year of the visas. So that's fairly well known. It was unofficially understood actually that the COS fee was also something that you shouldn't recoup from the employee, but that was never officially confirmed by the Home Office until the end of last year. So at the beginning of January, the Home Office clarified that sponsors couldn't recoup from employees the cost of a sponsor license fee. They also referred to mysteriously to associated administrative costs, although they didn't define what that meant at that point. And that's not generally an issue. It's not something that we typically see a sponsor trying to recoup, that sort of blanket license fee. It's mostly seen as an employer cost. But the Home Office also clarified at that point that sponsors were prohibited from recouping the cost of the COS fee, certificate sponsorship fee, where those COS were assigned on or after the 31st of December. Fast forward a few months to the 9th of April, the Home Office has updated their guidance to say that these prohibitions related to other types of sponsor licence, not just a skilled worker licence, but also that this point about associated administrative costs also applies to skilled worker costs. So it seems as if they forgot to add that wording, associated administrative costs, to the change they made in December. And so they've effectively said you can't recoup associated administrative costs, bit of a tongue twister, of a skilled worker COS assigned on or after the 31st of December. So that's a bit of a sneaky retrospective change, because you're effectively saying we are telling you now that you shouldn't have done something that you did in January, February or March. It's a retrospective change, which is just generally not, it's generally thought to be unfair. If anybody falls into difficulty because of that retrospective change, I think it's something that we could potentially challenge, but that's where we are. That's what the guidance says. So the big question then is what is meant by associated administrative costs? So that's the definition the Home Office has given us, pretty broadly defined. So what we're effectively saying is that for COS assigned, particularly in the case of skilled workers on or after the 31st of December, as a sponsor, you shouldn't be recouping costs for premium services related to the certificate of sponsorship, sponsor license. Not a particularly big deal. Generally, employers don't try and recoup that. Where it gets a little bit more tricky is that included in this definition is that you cannot recoup fees for legal advice related to assigning, maintaining sponsor license, importantly, assigning, requesting or applying for a certificate of sponsorship. And then more broadly than that, the costs of immigration or advice or services if the worker didn't have a genuine choice in whether or how to obtain that advice or services. So taking a step back and looking at it, it means that any organisation that has this practice, which is very common, of asking employees to pay back or be subject to an agreement where the employer may seek that repayment only if the employee leaves early, there is now a question mark about what have employers been including within those repayment agreements. So just to be clear, this isn't a, you could still recoup quite significant portions of the cost of a visa application. So you can still recoup the actual visa, the Home Office visa application fee itself. That is something that can be passed on to the employee. You can still pass on, you could, quite often the immigration health surcharge is something that's paid by the employee at the outset as part of the application anyway. If it's paid by the employer, you can recoup that. You can still recoup some legal costs, but they cannot be those that are relating to the sponsor license or the cause. And you would have to show that the worker had a genuine choice as to how they receive that advice. So in effect, the choice to go elsewhere and get other legal advice. And you can also recoup any legal fees for cause assigned before 31st of December. So quite a lot to take in there, but from a practical perspective, what you should be looking at are if you are an employer that seeks to recoupment in some way or other, and as I said, that's quite broadly defined. That could just be a clawback agreement that doesn't always kick in. But you should be looking at specifically those costs that were assigned on or after the 31st of December this year and the early part of this year, to see if you've got an agreement in place that relates to cause fees or legal fees, to see if that's either you've already got a clawback agreement in place that seeks to recoup that, but it hasn't kicked in yet, or in some rare cases, I guess, you may have had an employee that left within the first 3 months and you were seeking to recoup those costs. So look at what you've already got in place, particularly for that period since December, and then going forward, reviewing your template clawback agreements to make sure there's nothing in there that would fall foul of these new rules. And it can get quite complicated depending on how you're going to structure that repayment and whether you are going to try and seek some repayment or legal fees or just a portion of them. So those repayment agreements will take some fairly careful review and reading, and worth making sure that each time those agreements are issued, they're not just run out willy-nilly, that they are careful thought is given to each one that's issued to make sure that it complies with the rules. Unfortunately, the bottom line is if the Home Office find out that you are recouping payments in breach of these rules, then that could lead to potential action on your sponsor license, including it being revoked. So it's a serious issue that needs to be addressed properly and throughout the organisation. And so May's now going to talk about a related issue, because it also relates to recouping costs from employees, but a slightly different angle.
Thanks, Annabel. Yeah, there was another change that happened on the 9th of April, and that's literally just last month. And it is also relating to fees and costs of sponsorship, but at a different angle, not on what Annabel was just talking about on the recruitment. It relates to deduction of salary. So it means the amount, if you do clawback fees for immigration costs and things, and you do enforce the clawback, it could also be caught under this change itself. So the new rule itself states that sponsor who deducts any fees from an employee, a sponsored worker, that relates to business cost or immigration costs will have that amount that they've deducted from the employee subtracted from the salary that can be taken into account to meet the minimum requirement. So those who sponsor workers will know there is a minimum salary that sponsors need to meet in order to sponsor the workers. There's a minimum threshold and there's a minimum appropriate rate. So what they're saying here is that this change itself could affect whether or not the requirement of the salary requirement can be met, and is it going to be met throughout the period of sponsorship. So sponsors really need to take into account if the salary will be deducted, or if you do offer a loan, and there are amounts that will be taken back for immigration and business costs that could affect the individual meeting the minimum salary requirement. So the change itself is, the actual deduction itself is divided into the number of years that the employee is sponsored by. And that is the amount that's going to be deducted from the salary. So to give an example, because it's not easy to understand, I get it. If we have someone sponsored on a £40,000 salary, and then the immigration costs £10,000, you sponsor the individual for a 5-year visa, and you are looking to deduct back £10,000 from that salary itself. So for the 5 years, the £10,000 will be divided by 5 years. So £2,000 will be deducted off the annual salary, which reduces the annual salary to £38,000. And that is below the minimum salary threshold for a skilled worker at the moment, which is £38,700. So we just need to be very, very, very careful when you are looking at offering loans to employees to help them out with immigration costs, because it's quite high right now, or where you are enforcing a clawback where there's going to be a lot of fees that could be deducted back from the employee that relates to this cost itself. Next slide, please. The other changes we have seen recently is that the sponsors have been taking a lot stricter approach when it comes to existing rules, and making sure the compliance side of things are met too. So what we've seen is that when it comes to for example, the certificate of sponsorship allocation requests that you make to the Home Office for sponsoring workers, they could ask for a lot more documents, and these documents could include a lot of things that you would not expect to be providing. So it could be things like employment contracts, job descriptions are things you could expect to be providing, but it also could include things like hierarchy chart on where the role sits within the organization, things like we've had requests for 6 months business bank statements, payroll records, which are documents quite outrageous. So we have had success in pushing back to the Home Office when they make those requests, and the outcome of the certificate of sponsorship allocations have still been successful. The issue is that obviously they give such a short window to provide those documents, only 5 working days from the request date. So sponsors, when you're making certificate of sponsorship request, you need to make sure you are ready, have the documents ready in order to provide these to the Home Office, or at least have an explanation of why you need the certificate of sponsorships that you've requested for in advance. They have said that the request itself is quite random. When we spoke to other practitioners in the ILPA Association, they've said it's actually quite random, and it's not targeted at any sectors. But other lawyers, when we've talked to them, have said they've seen a lot more requests for certain sectors, like hospitality, like construction, and it's more for like smaller companies as well, rather than the bigger organizations. But that said, anyone could be affected by these if there is random checks, as per the Home Office have told us. We have also seen a lot of increases in applicants being interviewed, and that hasn't actually happened for many years since we've had the points-based system. They don't tend to interview applicants for visa, for the visa when they consider the visa application itself. But recently, we have seen a lot of applicants being requested to go for an interview before they make a decision on the visa application. And what they are testing here is there a genuine vacancy or genuine role that the individual is coming to fill? So they'd ask the individual itself about the recruitment process. How did you find out about this position? Where did you apply? How many interviews have you had? Things like that. They also want to know if the applicant itself have enough knowledge and experience to carry out the actual role. So they'd ask them about their previous experience, qualifications. It's like an interview that the Home Office is carrying out for you for that candidate again. And a lot of refusals that we have heard about is to do with the fact that the candidate isn't sure. They don't have enough knowledge on the actual position and what it requires, what they're actually going to be doing. And that has led to the Home Office considering that the role itself hasn't been genuine. Smaller companies and startups are also one that they're targeting a lot more. We've seen questions from the Home Office on whether or not this company is actually trading. Do they have enough turnover to pay their staff? Because obviously the minimum salary's gone up last year, so salary requirements are higher. So has this company have enough customers, enough sales in order to meet these salary requirements when they sponsor workers? So they ask a lot more questions in terms of turnover, contracts they have with clients, what work that they have in order to, sponsor these individuals, and what work they have in line to meet these requirements. And not all the requests are reasonable, okay, but it is a lot stricter sort of approach that we have seen from the Home Office recently, and it's adding to sort of the bureaucracy of the whole application process, and does cause delays as well to the visa applications. You do, as a sponsor, need to plan a little bit more ahead when it comes to sponsoring new people from overseas, or sponsoring generally in terms of meeting compliance duties. Next slide, please. This specific slide talks about the actual change that came in on the 9th of April. So this is actually quite sector specific. It relates to healthcare sector. So those who sponsor carers on the 2 SOC codes that are listed on the slide here will know there has been some recent changes. First thing, the salary has gone up. Salary threshold's gone up a little bit to 25,000, and the minimum hourly rate has also gone up with national minimum wage and things. But for these 2 codes, if sponsors were to sponsor for these roles, they do have an additional requirement that needs to be met from 9th of April. And this is a bit like it's a bit like a mini resident labour market test. I'm not sure how many people remember about the resident labour market test we had before 2021, but it was the need for sponsors to test the local market to see if there's anyone else that can fill the position before they hire and sponsor someone from overseas. So here, what they've done here, it's sort of a smaller scale. So they're asking the sponsor, before they sponsor anyone on these 2 SOC codes, the carer SOC codes, they need to make sure they talk to the local regional partnership to see if there's anyone else in the UK already which have been sponsored but have no job at the moment. So they've been sponsored by another employer in the UK. Maybe that employer has lost their license, or maybe they've just lost their job, or maybe for whatever reason they have no job at the moment. Could they hire that individual instead in the UK, so that they don't bring more people from overseas to the UK? And this requirement needs to be met, and a note needs to be added on a certificate of sponsorship, just to say that they have been contacting the local regional partnership on this, and they've confirmed that. And what the Home Office is going to do as well on the visa application, they will ask the local partnership, regional partnership, to see if this has actually been done. You can't just say it's been done. They will check on the visa application, and if it has, that's how they can process the application. And this is needed for any new hires on these roles from overseas coming to the UK, or anyone switching immigration category in the UK, unless they have already worked on that position for 3 months before the visa application. Okay, so I did say this is very specific to the healthcare sector and is for these carer roles. However, this could actually impact on future restrictions on what's to come for other skilled worker roles itself. So is this a start of bringing back resident labour market test for all sponsorship? I mean, who knows? It could be a good thing, because it makes it harder for employers to sponsor and less need to sponsor workers. But it was a lot of tedious document checks for those who do remember about it. Next slide, please. So the next slide talks about another recent change on the biometric residence permits itself. So the BRPs have all expired, and everyone on this call probably knows this. And what's happened is the Home Office has set up a new online system, and they want everyone to move onto that system, everyone to have electronic visas, and it's all well if everything works, of course. Most individuals with a visa that's still valid should have set up an online visa UKVI account to access and view and prove their immigration status. However, we have heard that there have been a lot of difficulties, a lot of issues, technical issues in setting up the account in the first place. And the Home Office sometimes are not helpful when you contact them, try to fix these technical issues. We've also heard issues when people have an electronic visa, but they're still being asked to provide a physical document when they're coming back from overseas at the carriers, when they're checking in for flights, or when they're entering port, and some port officers haven't been trained, so they're still asking for some sort of physical proof of their visa status. Banks, doctors, some of them haven't been trained to know that they need, they can do checks on immigration status on an online basis. So there are a lot of sort of teething issues with this transition itself. And for that reason, the Home Office has extended the deadline to use BRPs as proof of immigration status, even though they have expired, as long as the visa is still valid up until 1st of June. Okay, this deadline could extend even further. Employers, what you need to do is make sure individuals do keep their do register for their account, first of all, if they haven't got one, and if you have an account, please do make sure they keep the account up to date in terms of contact details, emails, and more importantly, or most importantly, is that they make sure their new passports, when they renew passports, are linked to the online account, because that's where they link the passport to their visa. And that is what allows them to come back to the UK when they travel overseas on holiday and they come back in. They can see from the visa that, they have they can see from the passport that they have a valid visa linked to it. Otherwise, there'll be delays at port and you'll have panicking employees calling. Next slide. And another recent change is the electronic travel authorization, the ETA. So that has come in on the 2nd of April, last month as well. And that is something that all non-British, non-Irish nationals and anyone else who don't hold a valid visa for the UK and want to visit the UK will need to apply for before they travel to the UK. So apparently the ETA is quite instant. It's granted within hours if it goes through well. And the Home Office has said 3 working days, but apparently it's much quicker than that. However, we have also seen refusals for ETAs. Okay. And the issue with this is that if it refuses, that means the individual who still wants to visit the UK will need to apply for a visa. And if they apply for a visa, it will take weeks to process. So you really need to plan a lot more ahead when you have a planned travel coming up, to make sure there is enough time to get a visa if the ETA doesn't come through. Once the ETA is granted, it is valid for 2 years. So there is plenty of time to plan ahead if you know that the individuals or employees have a lot of business trips to the UK from any other countries that they need an ETA. The other thing you'd need to note is that ETA itself doesn't guarantee entry. Even if they're granted, they could still be refused entry. And the reason why they would be refused could include the Home Office is doing checks and they can see that the individual previously had used NHS treatments whilst visiting and haven't paid for it, and they could just cancel the ETA on that basis, or they've had previous immigration issues, but they've realised after granting the ETA, so they could cancel it before the trip. Also, ETA itself is not a work visa. Okay, it doesn't allow anyone to work in the UK. It still only allows individuals to travel to the UK to visit only. So they can only carry out activities allowed as a visitor. If the port officers decide that, you know, the individuals coming in and the activities is work related, they could still refuse entry to the UK on this basis. If the individuals need to work, they need to get a work visa. Okay. So the Europe is also going to put in a equivalent of the ETA later next year. It's called the ETIAS. For all non-European visitors to Europe. So British nationals will be included, and we will need to apply for that when we travel to Europe from end of next year. So if you do have employees on, obviously you do need to plan ahead. I think the ETIAS system will help European countries track the number of days individuals are spending in the Schengen area. There is a stricter requirement of 90 days in any 180 days period for the Schengen zone. So not just one country. There's a smaller limit for visitors to European countries. So if you do have individuals traveling to Europe regularly, especially for business, do make sure they keep track, keep a list of the days they're spending there, and make sure it doesn't go over the 90 days. We have seen a lot more clients saying that the employees who do need to visit European countries, even if it's different European countries, being stopped at port, asking them the reasons for travels because they have spent very close to the 90 days limit in those countries in the 188 days period. So there is a stricter approach on the European ports as well. So you do need to warn all employees that do need to visit. There is a good chance they will be questioned if they go to Europe regularly for business purposes. And on that happy note, I want to hand you back to Annabel to talk about the next anticipated changes.
Thank you, May. So that brings us to the anticipated immigration white paper, which is being repeatedly delayed. Originally it was due out in March and then April, and now we're told it will be after the local elections this week, which frankly could mean at any point throughout the rest of the year. The Home Office has said repeatedly that this is going to be about, well, on the face it's about reducing net migration. They've set it out slightly more eloquently than that. They've said it'll restore order to our broken immigration system, linking immigration skills and visa systems to grow our domestic workforce and reliance on overseas labour and boost economic growth. So that is the plan. By all accounts, the delay has arisen in part as a result of conflicting objectives between different government departments. So on the one hand, you've got Yvette Cooper in the Home Office, who is her sole mission will be about reducing net migration, because the Labour government's very keen to distinguish itself from the previous government. It wants to send out a clear message that it is not intending to reinstate free movement, and that is their objective. On the other hand, you've got the Department for Education and the Treasury. The Department for Education is concerned that steps that might be taken in relation to the graduate visa, for example, would have a negative impact on the number of international students that are coming to the UK. So that would affect the revenue of universities. And the Treasury have a sort of different approach to the Home Office. So their concern will be that if the UK is not seen to be open for business, that will have a dramatic impact on growth. And fairly recently, we've seen data from the Office for Budget Responsibility, who have effectively said that that all new growth within the UK is going to be driven by immigration because of the need for 1 million new jobs to kind of promote that growth. So you've got these competing interests, and I suspect that there is that part of the reason for the delay, and also the means of reducing net migration but not stifling growth is going to have a fairly complex set of new policies. So on the one hand, you've got other groups within Westminster, so House of Lords committees pushing for exceptions to be made to the global talent visa so that tech workers, particularly in relation coming into the UK in relation to AI, will find it easier to come to the UK. Now, I think that's interesting, the kind of the global talent visa that some of you may be familiar with, which is popular in a way because you don't need a sponsor if you use that global talent visa. The difficulty is that it is got a very high threshold for success. There's relatively few people have used that visa. I think it's in, around the mark of 4,000 per year. So it's not much used because it's frankly quite difficult to obtain. They're suggesting that it be exempt from the IHS as a means of it becoming more popular. I think they're going to have to do something quite drastic to really attract people to come to the UK as tech workers outside the current sponsorship scheme. It's possible that they can give various discounts on the sponsorship fees, but we'll have to wait and see whether that sort of view from the House of Lords Committee gets taken into account. The other kind of rumour, if you like, is that graduate visa holders may be restricted in terms of the types of jobs that they can do. So, for example, at the moment, you've got someone who's an international student, graduated from a UK university, is able to apply for a graduate visa. That allows them to work in any job for any employer, regardless of salary, for up to 2 years. And the concern is that these individuals are holding jobs that are not really jobs that should be held by graduates. So there is the potential for that adjustments to be made to that route. And then we understand that the major sort of plank of this new policy will be some means of the Home Office being able to reduce sponsorship by effectively saying every time an organisation sponsors a new worker, they will also have to demonstrate that they are carrying out sufficient training within the resident workforce. Now, I think that's interesting because you talk to a lot of employers of any size and they will already say, this is, of course, we're already doing training. We are subject to the apprenticeship levy. We put a lot of money into an apprenticeship scheme. We are constantly training upskill our own workers and the resident workforce by making these opportunities for apprenticeships. So whether it will be tied in with the apprenticeship scheme or whether it will be a whole new raft of measures to prove how you are training domestic workers remains to be seen. I mean, one of the phrases that's used here is they need to be seen to not throw out the baby with the bathwater, in that if you're making it really much stricter for sponsors and creating more burdens, then you're going to potentially stifle growth. You're not going to have the skilled workers that you need in the UK. And after all, we have seen quite a significant drop in net migration as a result of the rules that came in relation last year in relation to raising the salary thresholds for sponsored workers. So net migration, it's always already on a downward trajectory. The question is going to be, how far do the government need to go in order to push that down much further? So lots to wait for. Ending on a positive note, as far as we know, it looks like it's more likely than not that there will be some sort of EU-UK youth mobility scheme. The Home Office, the Home Secretary in particular, wants to be sure that this isn't going to be seen as sort of opening up free movement again by the back door. So we would expect to see some sort of cap on numbers. But if the youth mobility scheme is introduced, that will be great for UK organisations because it will be used, I suppose, in the same way that the graduate visa users hold it is used, that an individual can come to the UK, they can work in any job for any employer for a limited period, say a year or 2 years, and then the employer during that time could decide whether or not they want to sponsor them. So that's ending on a sort of more positive note from an employer's perspective, that perhaps we will see restrictions put in place by the immigration white paper, but then this additional scheme that would free up European youth workers to come to the UK. I should make it clear that I don't think the youth mobility scheme announcement is going to be part of the immigration white paper. I think that will be separate. It's part of the UK's negotiations with the EU to reset its post-Brexit relationship. But we can expect quite a few changes in the coming months. But to be clear, I think this will be proposals that will then be subject to consultation. The immigration white paper certainly isn't going to be announcing immediate changes in the law. We will have some time to get used to it. So I hope that's been helpful. Some of the key takeaways, I think, from today, just to summarise what Carine and May and I have been talking about. Overall, it's just, you've seen the complexity both in terms of right to work check provisions and for changes to sponsorship. It's more important than ever to try and stay up to date with the changes and then look at how those changes actually affect your business. To see whether you've got adequate systems to make sure these things don't fall between the cracks. So, for example, you're looking at the recruitment provisions. Really look thoroughly at your current clawback agreements to make sure that they are drafted properly and that everyone in the organisation is aware that these are something that need to be carefully monitored. Make sure that these changes are regularly shared within the business. Often we see that really comprehensive training is put in place, but then that's not done regularly. So if somebody, if HR teams leave or individuals leave, then the new joiners don't have that same knowledge. So it's really important to keep repeating that. Be doing your own internal audits and training sessions. And then start reviewing your right to work processes now in anticipation of these applying to workers. I've spoken to a couple of large organisations about this, and because they have a very significant contingent workforce, they are going to need to introduce completely new systems to deal with the right to work checks that are likely to apply to workers. And then last but not least, of course, look out for the white paper. We'll be sending out regular updates as soon as we've heard that any of the changes, any more changes are in the pipeline. So I think we have a few questions that have come through. We've just got a few minutes left before the end of the session. And of course, if you've got any more questions, do feel free to put those on the Q&A now, and we will respond to those. But I'm just going to go through some of them that have come through on the Q&A. So someone has asked here if the IDVT provider. So earlier in the session, Carine was talking about the fact that an IDVT provider is obviously engaged to do checks in relation to British citizens and Irish citizen passport holders, and they can authenticate their passport. But we have seen instances of these providers also doing the share code check for non-British and Irish workers. And the question here is, if the IDVT provider extracts the share code document on behalf of the employer, but the employer completes the imposter check, does this provide the employer with a statutory excuse? Unfortunately, the answer to that is no. So if you've got an IDVT provider who is doing that share code check for you, they can still do it, but you need, to give you an initial view on someone's right to work, but the employer will need to do that again. So it does raise the question, why are you effectively asking, why would the IDVT provider do that in the first place? And there is a specific part in the employer right to work guidance that makes it clear that that approach won't provide the employer with a statutory excuse. And then we have, let me have a look at, see if we've got any other questions. So touching on that point we raised about deductions or the ability to recoup payments from employees. The very sensible question here, are we able to deduct if we are also making the application for our prospective employees' dependents? In principle, you could still either ask the employee to pay those dependent costs themselves up front, or you could pay them on the behalf of the employee, but then recoup that from the employee, those dependence costs. But there are still some things that are going to be excluded. For example, legal advice where that individual, the employee, even though this is for their dependents, hasn't been given a free choice. So for example, if you're saying, we're going to cover all the costs of your dependent visas, we're going to use this lawyer, and we will anticipate recouping those costs from you. In those circumstances, you would have to give the employee a free choice about which legal provider you use. So it's technical, and it's really worth looking at in detail about how you structure this, because it's not at all straightforward. And I think that now, oh, one more last question. Someone said, do the deduction rules apply to sponsorship prior to April the 9th? So again, that's a bit tricky. So the bit that May was talking about, where she was saying for the purpose of calculating salary for the purpose of sponsorship and whether the salary meets the threshold, those deduction rules apply to COS assigned on or after the 9th of April. Earlier on, when I was talking about recoupment, the recoupment provisions apply effectively retrospectively in some cases, so a bit cheeky on the part of the Home Office, from the 31st, COS assigned on or after the 31st of December. I think we've covered most of the questions. If we haven't covered anything else, we will pick those up after the session and be in touch with you. Thank you very much for joining, and I hope you enjoy the rest of your day.